on either Senate bill that's being heard today? Has everybody signed up? All right, we are at ease waiting on our senators. Thank you. And it looks like Senator Payne is going to be our first contestant. First one here, first one to get heard. Thank you, Senator. I appreciate it. I will now call to order the House Committee meeting, Juvenile Justice. We are here on a couple of bills. The first we're going to hear is Senate Bill 437 from Senator Payne. Senator Payne.
Yes, Madam Chairman and Committee. Thank you for allowing me this opportunity. Sorry, I just ran over from Capitol. This bill was brought to me by the Family Policy Alliance of Georgia, and it's really just nothing more than a clarification within the law, the current statute. Right now in Georgia, for a DNR order on a minor, a doctor has to have the consent of the parent, and if the parent's not available, then it takes 2 doctors to sign off on the DNR order on a minor child, that they agree. But in the statute, in referring to a minor, the language said any parent may consent orally or in writing to an order not to resuscitate on his or her minor child when such child is a candidate for non-resuscitation. And it was that may that was a concern because it's very ambiguous in the language of the law. As you know, may means there's options. And so it was really just to get rid of that may. Working with the Georgia Hospital Association and the Medical Association of Georgia, we came up with the current language, and so therefore we've been moving forward. It passed the Senate by unanimous vote, and we're just asking for your consideration.
Okay, I appreciate that. Members of the committee, do you have any questions for the author? There being no questions from the committee. Who's at 24? Representative Oliver.
Line 12 refers to except applies pursuant to subsection E, and E is not included on our bill here. What is subsection E?
That is the part referring to the 2 doctors consenting. That section E is where 2 doctors mutually consent for the DNR order. So, except for that case, does the parent have to consent? Is what it's saying.
So, if the parent doesn't consent to,
if the parent's not available,
or doesn't consent,
let's just give. I mean, a real bad situation. If the child was in a car accident and say, God forbid, something happened to the parent and they could not consent, then it takes those 2 doctors mutually agreeing to do a DNR order on a minor child, and the unavailability of the parent. So that's what that code section is referring to, that it's referring to except for that, unless unless an exception applies pursuant to subsection E of this code section, meaning the parent's unavailable and 2 doctors consent.
So it's not that the 2 doctors can override the parent, it's just that the 2 doctors may act if the parent is unavailable.
Yes, ma'am.
Okay. Thank you, Representative Oliver. Representative Kendrick, is that you?
Thank you, Madam Chair. So in line 11, it says of the minor's parent. So it only takes 1 parent, you're saying, to be able to give the consent. I think you mentioned something in the beginning that I missed about having 2 parents consent versus 1 parent.
The word parent, from legal counsel, what they explained to me was parent, and current language is parent applies to guardian or legal custodian by the code. Because that was one of the things that I had changed, was to put parent, legal guardian, or custodian, and they explained to me that was not necessary because parent is uniform for the legal person in charge of that child. So it'd be either one of them, yes.
Oh, thank you.
Okay. Any other questions for the author from the committee? All right. There are a couple of folks that have signed up. There's just, from the Family Policy Alliance of Georgia. Oh, I'm sorry, David. Did you have?
Sorry,
I'm sorry.
I just have a question. I know it's current law, but what happens if there's a disagreement between the two parents?
I would say that would probably, a doctor would probably not do it in order if that were the case because of the legal.
But it says of the minor's parent. So if we're in there fixing this, should we consider that at this time, or is that something that we're okay with? So if one parent says yes, they're separated. Resuscitate, don't resuscitate. Who do you follow? The one that says don't? Because it says you, I don't know. Do they go to court? I will leave it to the legal minds.
Representative Oliver, do you have any experience in that?
Unfortunately, I do. Either parent, if there's no court order, has equal authority to issue directions for medical services. And so I think in the eventuality where parents are in disagreement, the hospital is going to be not sure what they can do at that point, and a lot of hospitals have to deal with that. Not a lot, but it is an issue that comes up, and some occasions they will go to court to resolve that issue. But parents have equal authority if there's no independent court order.
Yes, ma'am. That was my understanding as well. Like I said, that would create a legal question as far as whether or not, but that would happen under the current statute and the current language of the way it is currently. That because even in the current statute it says any parent may consent. So therefore, you know, that would be a legal basis that would happen with regardless if we change this or not.
Representative, you have further questions?
Yeah, thank you. I do. And I know this is not the intent of your bill, but if we were in there, I'm just curious who settles that tiebreaker. I mean, because it seems like that would be more of an issue than fixing the language. That if we could, you know, I don't know if that's something we could settle now, but I would hate for, if it happens already, like, do they just not do it and make them go to court, or do we need to clarify that they don't move forward? I don't know. I mean, since we're in there already with the code.
I'm sure the author, since this is a hearing, so we do have some time. If the author would like to, if you would like to prepare an amendment, work with the author, you know, if that's something y'all can come to an agreement about, that's certainly something that the chair doesn't necessarily have an opinion about. But, you know, Representative, if you wanted to, you know, if this is an issue that you feel passionately about and you would like to work with the author on a possible amendment, that would certainly be entertained by the committee. So.
And also, you know, like I said, working with the Hospital Association and the Medical Association of Georgia, I would want to make sure that they were in line with that, whatever language their amendment that would be too, because they've been very helpful in helping us to make sure that we just clarify the law from that ambiguous may, just to make sure, to restate it in a different way, that it's no longer ambiguous. That was the intent of our effort.
Certainly, I appreciate that. Question from Representative Welch.
Yes, ma'am.
Okay, you were. Okay, yeah. Stop
Thanks.
hitting it.
Thank you, Madam Chair. Does the code define non-resuscitation or resuscitation elsewhere?
I'm sorry, what is the code?
No, does another provision of the code define non-resuscitation?
Fine print. This is pursuant to 3139-4. Persons authorized to issue an order not to resuscitate. That is what we're changing. As far as in that code section, it says it shall be lawful for an attending physician to issue an order not to resuscitate pursuant to the requirements of this chapter. Any written order issued by an attending physician using the term "do not resuscitate" or DNR or "order not to resuscitate," "do not attempt to resuscitate," DNAR, no code, no allow natural death, and order to allow natural death, or substantially similar language in the patient's chart shall constitute a legally sufficient order and shall authorize a physician, healthcare professional, nurse, physician assistant, caregiver, or emergency medical technicians to withhold or withdraw cardiopulmonary resuscitation.
What was the code section you were reading?
3139-4.
Thank you.
Any further questions from the committee for the author? Seeing none, we'll move into public comment. The Family Policy Alliance of Georgia, I think I'm gonna, if you would introduce yourself, you can speak from the podium there.
Okay, great. My name is Cole Musio. I'm the President and Executive Director of Family Policy Alliance of Georgia. And I appreciate y'all hearing this bill. I think this is an important thing. Y'all are asking some great questions. In addition to my role as with Family Policy Alliance, I'm a father. I've got a 3.5-year-old, a 2-year-old, and a 1-month-old, so I'll appreciate your indulgence in me rambling a little bit. I don't get much sleep these days, but this bill, the frightening vagary in this language where it says a doctor may issue a do not resuscitate with the consent of the parents is frightening to me as a dad. And y'all are asking some great questions that get deeper into what, how to issue a DNR and some medical care. But the focus of this bill is to make sure that no parent has the nightmare of seeing a DNR on their child that wasn't issued with their consent. There are some great medical professionals here in Georgia. We've got a great hospital association, great doctors, great people that are trying to provide great care for our kids. This bill is not an attack on them at all. It's to clear up language to make sure that no parent ever experiences a DNR being put on their child without their consent. Y'all have some tough decisions in this legislative body, and I appreciate the work that y'all do. This is not one of those tough decisions. It's pretty straightforward. The bill passed 52-0 in the Senate, and Senator Chuck Payne is a very charming, very good-looking guy, but he didn't get unanimity in committee or on the Senate floor based on his charm, good looks, or the sheer impressiveness of his beard. This was something that got through because it makes sense, and so I'd ask for a quick vote. We can make some fixes in other parts of the law. This specifically addresses the minors, so if y'all want to explore other areas, that's great. But I'd ask for a quick favorable vote. Let's get this on the floor and get this over to the governor. It just makes too much sense not to. So thanks.
Okay, all right, you have a question? Representative Wilkerson.
I'm full of questions today. I thank you.
Yeah,
Thank you
go
for.
ahead.
I think you did kind of answer a question I was just asking. So it really isn't a clarification of the law. We actually are changing the law. And to your point, because right now it sounds like the concern may be that a doctor may do it without the parental consent, and that this says you have to have the parental consent, which I'm not saying is a bad thing, but we are changing the law to make it so that parents do have to do that. Now the question is, should it be one or both parents that consent to that? So it is a change in law, not just a clarification.
Well,
If I can respond, actually it's not, because like I said earlier in that subsection of this is just this referring to minors, but in that section it already states that a parent has to give consent. So therefore, it's not changing the law. The earlier language says that the doctor's a DNR order must have the parental consent, but it's not. So this is literally not changing the law. It's just clarifying this language. So therefore, because what that line was really, the understanding of what that line was trying to say, that when a parent gives their consent, that they may orally consent or in writing consent. So the may was really to show that orally or in writing they have a choice. That was the reason for the may, but that may saying that a parent may consent still is very ambiguous, and I didn't want anyone to misinterpret that to saying, well, if a parent may consent, then I don't have to have their consent. And it's really just, and that's one of the reasons why I work with the Hospital Association, because it really takes the liability off them too. It helps to release that liability in case someone were to make a horrible, tragic mistake in misunderstanding the letter of the law.
Yeah. And my understanding, both with law and practice, is that this is what's applicable now. But if this catches one or two incidences that would have slipped through, I think this is important. And the other issue, there are going to be other medical disputes in care between parents, and I would imagine that that's dealt with in other areas of law too, and how to resolve medical disputes. And I don't know that that's necessarily has to be in the DNR section, but maybe worth exploring.
All right. Representative Sharper.
Thank you, Chairman. Being a medical professional for about 30 years now, I think what I'm seeing here, even on DNRs, a lot of times you have time to actually, if you see a person in a bad situation and it's kind of a illness, you have time to do a DNR, and that's your written consent. by the family or, the parents. But sometimes there are emergency situations where you're on the spot and it may be a little illness or maybe something happened and you're looking at that child and you're working on them and you look at that parent and they may say, I don't want to do anything. I don't want to take them through that and bring them back as a vegetable, whatever. Then that's giving that oral opportunity. If not, if it has to be written, even though you're working on that child and that parent say, look, I don't want to take my child through that, please stop. If you don't have a written DNR a lot of times in your hand, you have to continue working until you get either to the hospital or physician or something like that. But if I'm looking at this may give that opportunity that you're right there, and sometimes you're not going to have two parents. You're going to have that one parent that's there, and this may open up to give that opportunity for more oral versus just written. So with me looking at this bill, in that first line that they, took out, by taking that out, I think it makes it clearer in what we've added in with a minor child as a candidate for, everybody to see the bill. But I think this will clear up some things in a situation. And to be honest, we know that, parents love their children and they want a lot of things to be done. But there's some cases where that physician or that medical professional can say, look, we're at that end, and that parent say, I still want you to do something. But, you know what I mean? You got to have something in writing to help the professionals as well as the parents. But, thank you for bringing this. I think it's something that we really do need to look at.
Thank you, sir.
Thank you, Representative. Any other questions for the speaker? Okay, there's nobody else that's spoken. Thank you. I appreciate that, sir, for coming and bringing your thoughts. Like I said, this was a hearing only, so we appreciate that. So I'll notify you later of whenever the committee's going to take action. Thank you,
Well,
Senator.
thank you. I
Appreciate
appreciate
it.
your time and appreciate your input.
Thank you. I appreciate
Thank
it.
you so much.
Next on the agenda is Senator McCoon. If you'll just clarify for us what LC you're working from.
Yes, I'm working from LC 410930.
Thank you.
Thank you very much for having me this morning. The bill that is before you, Senate Bill 74, makes a single change to the code at line 13. This has to do with Georgia's law regarding parental notification of abortion. And current Georgia law does not supply, or current Georgia statutory law does not supply a standard, an evidentiary standard, for the judicial bypass process. So an unemancipated minor seeking an abortion who does not wish to have their parents notified must petition the juvenile court in order to bypass that notification requirement. As you'll see from the bill language, we are doing nothing to change what must be proven. All we are trying to do here is to supply the evidentiary standard that the court uses to determine whether or not the proof has been made sufficient to grant the requested bypass. If you look around the country, I'll back up. I had a constituent bring this issue to me who has been involved in some of these hearings and who was concerned to learn that under Georgia case law, the current standard is preponderance of the evidence. And of course, he believed, and I agree with him, that this should not be a close call for a judge to make. This is an incredibly consequential decision in a young girl's life, just probably the most consequential decision that has been made up to that point. And if the court is going to grant the bypass, we certainly believe that they should do so under a clear and convincing standard. There are 22 states around the country that have chosen by statute to supply an evidentiary standard. Of those, 15 have chosen clear and convincing, so we're not really breaking any new ground by establishing that evidentiary standard under Georgia law. If you think about it, we're talking about a surgical procedure. Most other non-emergency surgical procedures that a minor would be subjected to would not only require parental notification, but would require parental consent. And so what we're talking about here is a relatively small change in the law, but I believe one that is certainly in the best interest of minors who are petitioning the court seeking judicial bypass. I believe that sort of covers the subject in general. I'll certainly be happy to stand for any questions.
Okay, I appreciate it. Senator, you have a question from Representative Kendrick.
Thank you, Madam Chair, and happy International Women's Day to all you women. So let's talk about other people's ovaries now. So if we could talk about the court case in the interests of Doe. This is a Court of Appeals case. It's 319 Georgia Appeals 574, and there's a citation at 577 that talks about the preponderance of the evidence being the current standard. So I understand you're trying to raise the standard to clear and convincing evidence, the clear and convincing standard. So could you tell us what case has happened or how many cases where there's a gap in evidence that makes it so urgent that we need to change it statutorily if we already have it in case law?
Well, Representative, as you know, these proceedings are not public proceedings. There are not records that are maintained. You may hear some testimony, I know we did on the Senate side, about some reports about how many of these petitions are filed and so on. But we really don't know how many petitions are filed. We really don't know what evidence is put on because all of this is done under seal. So it's difficult to say that. What I can say is that I think that using the same standard of evidence that we use to determine who's negligent in a car accident to determine whether or not a minor's parents should be notified before proceeding with an abortion, I think, and I think a lot of others agree, that that's not an appropriate standard, that the judge should be more certain that what has to be proven under the law has been proven before granting that bypass. And obviously, lawmakers in 15 other states have also come to that same conclusion.
Madam Chair, am I
Sure.
allowed a follow-up question?
Sure.
So, based on saying that we don't even know if it is a problem, if there's no evidence to say that there is a problem.
And to be clear, it is an impossibility to know that because these proceedings are conducted under seal. I mean, this is not something that there's been a lack of research. You can't research it because for obvious public policy reasons, when this petition is made, it is not like legal proceedings people would normally think of where everything's out in the public view. This is a proceeding that is conducted with a great deal of confidentiality. So again, the question is from a policy standpoint, if you think that it is appropriate to use the same standard of evidence that you use to determine negligence in a car wreck case, as you do for in my opinion, the incredibly consequential decision for the young girl that's involved here, obviously you're fine with the current standard. If you agree with me that given the weighty nature of what's being decided here, that in making a determination about whether the parent should be in any way involved in that process or not should require greater weight of evidence. And that's the argument that I made in the Senate. That's the argument I'm making here today.
Okay, thank you, Representative. Representative Welch.
Thank you. Senator, let me ask a question. We're talking about children who are under the age of 18, right?
That is correct, Representative.
And I think this committee, you would not know this personally, but this committee has spent a lot of time over the last several years discussing the mental capacity of those that are under age 18. I've heard arguments from members of this committee about the capacity of young males in their 20s to make decisions, and I've heard discussions about that there's the development of the brain is not such that we consider that the person can make some of the adult-like decisions that they make. They don't have the capacity or the ability, or the brain hasn't fully developed at that point. So in essence, what you're doing is you're actually just elevating the standard so that we're having a very thorough check on what that decision-making process is when deciding as a minor, one with a less than fully developed brain, to make a decision as to the termination of a pregnancy.
That's absolutely right, Representative. And I think it's important to stress and underline, we're talking about the law in Georgia dealing with parental notification. I mean, there are a number of states that require parental consent in these circumstances. So all we are talking about is the standard of evidence a judge is going to use to determine whether the parent shouldn't even be notified. And that's why I think, along with what you very articulately stated about the mental capacity, it is just very important that this not be a close call. This be a clear determination by the judge under the weight of the evidence presented.
Thank you.
Thank you, Chairman Welch. Representative Wilkerson.
Thank you, Madam Chair. So I guess, can you think of a situation where a child may not want to tell their parent,
I'm certain.
and where a judge would determine that that's in the best interest? And can you give me an example?
Well, I think if you look at the bill, and this is existing code, lines 17 to 19, one of the things that can be proven, and it's an either or not both, is that notice to a parent, or if the unemancipated minor is subject to guardianship, the legal guardian pursuant to Code Section 1511-682 would not be in the best interests of such minor. And I think one of those examples would be if the minor's being abused by a parent or legal guardian. That would certainly be an example. Or if the minor fears that the receiving knowledge of this would result in some sort of abuse. So, I mean, there clearly, as the legislature enacted this statute many years ago, a number of situations I'm sure we could all discuss where subparagraph 2 would be triggered.
Okay, so following up on that question then, so in the case of an abuse or rape or something of that nature, how do you prove that to a judge? How does a parent, because it's he said, she said a lot of times, so how do you provide clear and convincing evidence that that child has been abused unless you got it on videotape?
Well, I think the question that you're asking is an allegation of abuse alone, standing alone, sufficient to meet a preponderance standard even? And, again, without knowing all the circumstances of an individual case, I'm not exactly sure how any of us can answer that question.
A follow-up question though, so, but what you're asking us to do is to take a child that comes to the courtroom that right now says, I have been abused by my parent and molested by my parent or uncle or somebody else, and you will make that child then provide a higher level of evidence to do that. We have already determined, as he said, as the gentleman said, that sometimes things are so important that we have to take those steps. So if you look at mandatory reporting in schools, they don't care if you can prove it or not, but if you hear any allegation of abuse inside of a school, if that teacher does not report that, they get arrested. So what we're asking to do is say that what we're saying over here is that you have to report everything and then we'll investigate it. But if I come into the courtroom and I am pregnant and I say this is the case, then you basically make that child go back to that family and then try to find evidence that would allow that standard to go up. So, I mean, that's my only concern, because I agree with you that that may be a case, but I just don't know how you prove that. I mean, we see in the news right now where there's allegations of somebody did something to somebody else, and unless they got on videotape, we don't believe them, or unless there's money being changed hands by, $130,000, we don't know. So, but my point is that I just want to make sure that we're not raising that standard too high.
I'm gonna try to answer the question that I think was in there somewhere. The number one thing I would say is I think you're making an assumption that an allegation of abuse standing alone would satisfy a judge under a preponderance of evidence standard. I don't really believe there's, I don't think there's a case out there that would support that position. I think that what we are talking about is if the court is making that finding, that they should make it under a clear and convincing evidence standard. I think it's an appropriate standard of proof. I think it's a standard of proof that's worked in 15 other states without any evidence of someone being subjected to additional abuse by an abuser. If you're aware of any of those examples, I'd be very interested to hear them. But I think that what we're really talking about here is what should be the weight of the evidence in a case like this. And I think when you're talking about whether or not parents should be involved, just being notified about a decision to have an abortion, that using the legal standard that is used in a car wreck case to determine negligence is not an appropriate standard, and that there should be a greater standard of evidence in play. And I certainly understand that reasonable people may differ on that, but I don't think there's any evidence whatsoever that this change would lead to any minor child being endangered. And if that was the case, and if I had any information to indicate that it was the case, I would not be sitting in this committee presenting this bill.
Okay, all right.
Yep.
Well, we can circle back. There's a lot of other folks that would like to ask questions of the author. So, Representative Cantrell.
Just so we're clear, Senator McCoon, what you're talking about here today in no way affects the minor's decision-making policy. She can make the decision. We're not talking about consent. We're just talking about notice.
That is absolutely correct, Representative.
Okay, I just want to make sure everybody's clear on that.
Okay, thank you, Representative Cantrell. Representative Oliver, do you still have a question? Okay, committee members, if you hit the button, it starts flashing here. If you hit it again, the button it stops flashing. So it flashes here. So I just will, for committee members, if you just hit it once, it starts flashing and we're good. Okay, thank you, Representative Oliver.
You said that we didn't have any information on these, but I have information in front of me that there were only 42, I don't want to say only, there were 42 petitions for judicial bypass statewide.
And
so there is information on the numbers.
And I think if you look at that document, Representative, it's the same one I was presented with at footnote 1, they essentially disclaim and say, these are self-reported numbers. So there's not really I certainly don't have any confidence in self-reported numbers. So yes, there's a sheet of paper in front of you with some numbers, but is there any state agency that's standing behind it and saying, yes, this is exactly the number of petitions that were filed, this is exactly the number of dispositions? No, there is not.
Have you ever asked the Council of Juvenile Court Judges how they keep their caseload data?
We had some testimony in the Senate on this subject, and as far as I know, other than the document that I believe you have in front of you, which I forget which state agency it's from, but where at footnote 1 they specifically disclaim the numbers. I'm not aware of any report, but I would be very interested to hear about it.
Did the Council of Juvenile Court Judges testify or not testify in the Senate?
They did not have a position on the bill as far as I know. They were not present at the committee.
Did anybody testify on any data kept from the Council of Juvenile Court Judges or AOC on numbers in the Senate?
I believe the document in front of you is an AOC document.
Okay, so this is a Office of Administration of Courts document that has numbers, and you don't credit them?
Because they don't at footnote 1 of that same document.
Well, I don't see a footnote, but I'm surprised to find that they don't have any data on the kind of cases that they have before them.
The only data that I've been presented with is the AOC document that you're referencing, which we had some significant discussion about in the Senate committee, and several members observed the fact that that was self-reported data and that there wasn't some sort of independent count that could be verified or audited. And maybe there is, but we have not been presented with one.
Self-reported by the petitioner or self-reported by the court?
The footnote, I believe, just refers to it as self-reported. I don't believe it says whether it was self-reported by the participant or by the court.
I don't have a footnote, but perhaps we can have some real evidence on what we're paying AOC to do data. We're paying Representative Welch and I have been involved in this issue about data from juvenile courts for a good while, so I'd be surprised that they don't have any credible data to your perspective.
Well, I'd be very interested to see it.
All right. Thank you, Representative Oliver. Representative Kendrick.
Thank you, Madam Chair. I have two questions. The first one is that, what is the current age of consent so that a young woman you're not committing statutory rape against her in the state of Georgia?
I don't know that off the top of my head. I know that the age of majority in the state's 18, and that's the subject of the bill. It has to do with minors under our parental notification statute.
Well, my point is, and somebody correct me if I'm wrong, but I think the age of consent for it not to fall under statutory rape is 16 years old. So what I'm getting at is that someone is old enough, 16, 17, 18 years old, in order to have sex and it not be statutory rape. And what you're asking us to do is to say she's not mature enough to not have to tell her parents. And I understand that's current law, but now we're raising the standard. So I'm having a hard time reconciling how the age of consent is 16 for, not to have to commit statutory rape, yet we are saying that they're not mature enough to not have to notify their parents about this and raising the standard.
Yeah, I think you're conflating a couple of things that aren't really related. When you have a minor, if this bill were the law today, it would not change what has to be proven, which is that the unemancipated minor is mature enough and well enough informed to make the abortion decision in consultation with her physician independently of the wishes of such minor's parent or guardian. That is not changing. As Representative Cantrell pointed out, it is also not changing the fact that after that notification, that minor is free to proceed with the abortion without their parents' consent. All we are saying is, what standard of proof should there be regarding the maturity of the minor? And I think that Georgia should join with the 15 out of the other 22 states that articulate a standard to have the higher standard of clear and convincing evidence.
Madam Chair, can I ask one more question?
Follow up? Sure.
So how many judges have regretted granting an abortion, saying, I wish that we had a higher standard, or I wish that there was more evidence? How many judges in the state have either publicly said that or maybe came to you in private and said they regretted and wanted a higher standard?
I haven't taken a survey of judges, and I don't know that the level of judicial regret is a basis upon which we should be making public policy. I think the basis we should be making public policy on is what is in the best interest of that minor child. And in this case, where you're talking about an incredibly consequential decision, and this judicial bypass allows that minor to make that decision in the total absence of parental involvement, I think doing perhaps additional trauma to that child. Again, this should not be a close call for the judge. This should not be the standard used in a car wreck case. The judge ought to be very, very certain that this is the right decision and that minor is mature enough to make this incredibly consequential choice.
Thank you, Representative. Thank you, Senator. Representative Sharper.
Thank you, Madam Chair. I think in this situation, you continue to go back to a car accident and then this situation, which is totally two different things.
Which is why there need to be two different standards.
Right. But one thing I'm looking at, when we say by clear and convincing evidence, we're looking at the judge making decisions based on if there's a standard that's brought up. And my thing about the standard, if you have like a cookie cutter situation, it may take the opportunity of the judge to be able to deal with this particular minor, because all the minors that come, they may not, I know they're coming maybe for the same thing, but their situation may be totally different, their mental status, different things. Do you think that will take away the judge's ability when you do have that, on the line thing, but not per se that he has to or she has to go by this particular standard? This is just my question to you. Do you think that's going to take that power away to say, well, this situation, even though we're almost right here at the standard, I still need to do this, but they don't quite make that particular standard? That's just my question to you.
Certainly. I think that, the clear and convincing standard is found throughout our code. Our judges are very familiar with it and apply it regularly. So I don't think it takes away the ultimate decision that's going to be made by the judge. It's just a question of the weight of the evidence. And certainly I will freely concede it is easier to prove something based upon a preponderance standard than a clear and convincing standard. So there does have to be a greater weight of the evidence, but I don't think it handcuffs the court. I think it's just going to maybe in some circumstances require the court to make a more significant inquiry when presented with one of these petitions.
Okay, I mean, that's my biggest concern, that when we get in that situation, if it's cookie cutter, then really they got to go by that standard because you've set that standard. Thank you.
Yes, sir.
Thank you, Representative. Representative Wilkerson, you have a follow-up? Quick follow-up. We have many members of the public that have also signed up to speak, so.
Real quick, I apologize, real quick. So I don't know, I'm back to the whole rape case. So you said it's a pretty high burden right now. You don't have any numbers. So what would be the difference between preponderance of evidence and clear and convincing standard if in the case, very specific case of a rape, I mean, I'm sure it's happened before. Can you tell me what they would have to prove under preponderance of evidence versus what they would have to prove under clear and convincing evidence?
Well, obviously, it's difficult to answer a question since every one of these cases would be different. And the very thing we're talking about is the standard by which the court weighs facts that are presented to it. So I don't think it's possible for me to answer to you, that question because, again, the facts of behind every one of these petitions are going to be different. The evidence that's going to be presented to the judge to weigh both for and against granting judicial bypass is going to be different. What I do think is that of the 15 states that have established this standard in their statutory law, I am unaware of any problem that has arisen with regard to the scenario you're discussing. And so again, I'm happy to be educated on that if there are some cases, but I'm not aware of any.
Thank you. So thank you for answering that. So you basically don't know and you have no numbers to back up the fact that, or any data. I just wanted to clarify that. Thank you.
Okay,
Yeah, I
all
think it's important to clarify, if I may, that the reason there is no data that I'm aware of that's available to evaluate some of the questions that have been asked today is these proceedings, as I believe everyone on the committee understands, are conducted under seal and are private. It's not from a lack of research or a lack of interest on my part.
Thank you. Representative Holcomb.
Thank you, Madam Chair. Good morning, Senator McCoon.
Good morning.
My question is with respect to the parental-child relationship, which, of course, I think we agree is important. And with that, I understand where you're coming from and what you're trying to do. And I've heard you say several times using the analogy to the car wrecks and the preponderance of evidence standard. As you and I know as practicing lawyers, the standard of proof is really the ball game in litigation. It's extremely important. And one of the standards of proof that I think is relevant is emancipation, which is a preponderance of the evidence standard and not a clear and convincing standard. So would you like to comment on that?
Certainly. I think, again, we could have a public policy debate about the existing law with respect to emancipation. I'm not here today trying to change the law on that. I do think that when it comes to parental notification of abortion, which I think wherever you land on this debate about abortion, I think everyone would agree that it is a consequential decision. It is a decision that has the potential to cause a great deal of trauma. And when that decision is made outside of any parental involvement for a very young person, that it could be life-changing, life-altering, in a very negative way. And so I think that when we decide that we're going to exclude the parents from that process, that the decision maker, that judge sitting in a courtroom without the parents present, I think that judge needs to have a high degree of certainty that this young person is prepared to make that decision on their own. And I think that's why it's appropriate to have a clear and convincing standard.
Thank you, Representative. Thank you, Senator. So we are going to hear from a few speakers. You will be limited to 3 minutes. I will cut the mic off. So the first person that we're going to hear from is Megan Gordon. Ms. Gordon, will you introduce yourself to the committee?
Yeah, if y'all wouldn't mind giving me a second to set my own timer so I can just keep myself.
I've already
on
started
track?
one.
Okay. So, hi, my name is Megan Gordon. I am the Public Affairs Coordinator for
Pull the mic
Feminist.
down just a little bit. So we
Better?
Can, yep.
I'm the Public Affairs Coordinator for Feminist Women's Health Center, and so I wanted to start by walking y'all through the process from beginning to end. And I want to emphasize that I appreciate that having a conversation about young people being able to get abortions without their parents being notified can be uncomfortable, and I want to really emphasize this is not for healthy families. This law was not created with healthy families in mind. And so I want to walk through the process real quick. Feminist Women's Health Center is an abortion provider. So I sat down with the folks up in our clinic who make patient appointments, and I said, okay, I am 15 years old. I'm calling you to make an appointment. Walk me through all of this. What happens? So in the normal process of making an appointment, birthday is asked. Obviously, when that number doesn't add up, at least in our clinic, our folks say, okay, here's the problem that we have. They explain the parental notification requirements and make every effort to persuade the minor to tell their parents. Because I think we can probably all agree that the ideal scenario here is the young person and their parents sitting down and having a conversation. If it becomes clear that the young person does not consider that an option, we accept that they know their family better than I do. Most often what we hear is, I don't want to disappoint them, to which the response is usually, well, I'm sorry, honey, you're going to have to tell them. But we also get a lot of, I'm afraid they're going to kick me out of the house, in which case, rather than condemning young people to being homeless and pregnant, we explain the judicial bypass process and give them that option. The next step is they have to come into our clinic and get an ultrasound to confirm the pregnancy. That costs a little over $100. So they have to find a way outside of school without their parents to get to our clinic with the money to confirm a pregnancy, because if they have not medically confirmed the pregnancy, there's nothing to go to court and argue about, right? And then we connect them to volunteer lawyers who can walk them through the process of going before a court and speaking with a judge. I'm running out of time, so I'm going to skip through a little bit of what I was saying. As Representative Holcomb pointed out, this process, the standard of evidence is the same as emancipation at the moment. So if this bill were to be passed and signed into law, it would be easier for a young person to become legally made an adult and then go get an abortion than it would be for them to simply get this exception, which might be needed to keep them safe from abuse in their homes. And all of the evidence that we have before us is that preponderance of the evidence is working well as the appropriate standard. As my grandma always says, if it ain't broke, don't fix it.
Thank you, Ms. Gordon. I appreciate that. And if you have any follow-up comments or anything like that, feel free to, give something to my secretary and we can provide that to the committee members.
Yes, ma'am,
Thank
I will
you.
do that. Thank you.
Angeline?
I'll try to keep this quick, but I'm a little nervous, so please bear with me. Thank you all for the opportunity to speak today to voice my opposition to Senate Bill 74. My name is Angeline T., and I'm a board-certified family physician and fellowship-trained in family planning. I'm speaking today in my capacity as a fellow for Physicians for Reproductive Health and present a letter to you that you all have copies of on behalf of multiple providers of comprehensive women's health care in Georgia. The other physicians who signed this letter were unable to attend today because they are working to provide family planning care, labor and delivery care, emergency and primary care. As physicians who care for Georgians every day, we urge you to reject Senate Bill 74. This bill would increase barriers to accessing abortion for our young patients. We support the role of our government in creating supportive policies that help our communities thrive. However, Senate Bill 74 is not one of those policies, and it would be dangerous and harmful for some of our most vulnerable young patients. Numerous medical and public health authorities also support minors' direct access to reproductive health care, including abortion care. The American Medical Association states that physicians should strongly encourage a pregnant young person to discuss her pregnancy with her parents. However, ultimately, the decision of whether to involve a parent should rest with the patient. The American Academy of Pediatrics also encourages parental communication and recognizes that mandated parental consent can have an adverse impact on families and that it increases the risk of medical and psychological harm to the adolescent. And the American College of Obstetrics and Gynecologists also supports this as well. So Georgia already has mandatory required parental involvement, and so I believe that this legislature should not add additional barriers to adolescents' right to obtain judicial bypass. So as we've said, not every young person is blessed with a safe home life. We know that forcing patients to let their parents know about decisions to end an unplanned pregnancy is not the solution to a damaged or abusive child-parent relationship. Some young patients fear parents' anger. Others experience violence in their homes, maybe victims of sexual abuse. I've had patients who've said that they will be kicked out of their home if they tell their parents about their abortion. For patients who cannot safely turn to a parent but live in states like Georgia with mandated parental involvement, judicial bypass is an important option. But Senate Bill 74 does not solve the problem of poor family communication. A courtroom is an intimidating place even for adults, and so the current process already presents a formidable obstacle to a young person seeking an abortion. There are issues of navigating a complex legal system, going before a judge, facing questioning from strangers, and I'll wrap this up, figuring out transportation and time away from school. The data that I do have says that there were about 36 of these cases granted in 2016, so we know that this is not a common occurrence. When young people decide they have to go through this process, rather than speak to a parent, they have valid reasons to do so, and we must trust them. I'd also just like to respond. So the current research that we do have does tell us that abortion does not lead to negative mental health consequences. And if this is an issue in discussing this, would be happy to provide references for that.
Okay. All right.
Thank you for your time.
Thank you, Doctor. I appreciate it. Cole Musio.
Hey, I'm back. Well, this is a very strong and impressive committee, and I appreciate the questions that y'all have. I imagine a lot of bills get strengthened going through here, so thank y'all. Should this bill pass, just a little bit of perspective, and I'm going to do something I don't often do, and that's cite Planned Parenthood. According to Planned Parenthood, 25 states require parental permission. So should this bill pass, there would be a majority of states. Georgia would be among the states that are, depending on your perspective on this issue, and I understand there are different opinions in this room, and that's fine, that's good. Depending on your perspective, Georgia would be at the top of the easiest states to get an abortion, or towards the bottom of the easiest states to get an abortion in the country. 25 states require parental permission. This does not require parental permission. It just strengthens the requirement for notification. So I'd encourage the committee to consider that. This bill still puts Georgia among the easiest states for minors to get an abortion in the country. Thank y'all.
Thank you. I appreciate it. Chris Bruce.
Good morning, Chair, members of the committee. Some of the comments that have been made, I was going to make in my statement, so I'll be brief. My name is Christopher Bruce. I am the Policy Counsel for the ACLU of Georgia, an organization that fights hard every day to defend the civil liberties and civil rights of all Georgians. The proposed bill wishes to change the current Georgia standard baseline code from preponderance of the evidence to clear and convincing evidence. As stated before, preponderance of the evidence is a code and standard that's in not only this section of the Juvenile Justice Code, but throughout the whole section of the Juvenile Justice Code, which this committee has overhauled previous years, especially in the emancipation standard. Let me read that to you. OCGA 15-11-724 A child who petitions the court for emancipation shall have the burden of showing that emancipation should be ordered by a preponderance of the evidence. By a preponderance of the evidence. So after years of hard work, after years of going through the Juvenile Justice Code, this bill changes everything by putting the standard of proof out of whack. And as stated before, the senator is saying that it's easier to get the standard of proof in a car wreck as a standard of proof for becoming an emancipated adult. That doesn't make any sense. You will have, if this bill passes, you're sending the signal that a child should go and become emancipated from their parents before they actually go ahead and become able to get an abortion. I think that this committee should actually table this piece of legislation or kill it, which I would prefer. But at least table this legislation and look towards the other standards of proof that are in this Juvenile Justice Code, as been stated before. I'll entertain any questions.
Any questions? All right. Thank you, Mr. Bruce. I appreciate
Thank
it. Last up is Dave Baker.
Thank you, Madam Chair, members of the committee. I'm Dave Baker. I'm Executive Director of Faith and Freedom Coalition of Georgia, speaking in support of this bill. This is a very narrowly drawn piece of legislation. 4 words: clear and convincing, by clear and convincing evidence, which establishes an evidentiary standard for a petition by a minor of a momentous, literally life and death decision. This does not change the criteria for granting such a waiver. There's 2 criteria, only one of the 2 which need to be met. It merely establishes an evidentiary standard without which it's totally up to the discretion of the judge. Any evidence standard, preponderance of the evidence, clear and convincing evidence. Furthermore, these are hearings. These are not jury trials. And this provides consistency for all involved, including and especially the minor who's seeking the waiver and an abortion. Thank you very much.
Thank you, sir. I appreciate it. Any questions from the committee?
Could I please be recognized just for 1 or 2 minutes?
Sure.
My name is James Nelson. I am just a friend and donor of post-abortion and healing path is what they call it. And I do have some backup for the claims that I'm making, and I've got some that I'll pass to the committee, and you may look at it. And I just want to read this one thing. The hurt woman, abortion doesn't just kill babies, and people don't know this. It doesn't just kill babies, it does harm women. Women can be hurt physically and emotionally from abortion. The harm caused by abortion is not mentioned very frequently, but can still be extremely serious. Physical risk of abortion depend on the procedure used, but the most common methods carry the risk of cramping, abnormal pain, infection, which can lead to serious illness and mother's death even. Proliferation of the uterus, I'm not a medical person, please, lay person, but it can cause serious things. And then the emotional, which a child, I didn't understand until recently. I'm sure a lot of you didn't, but a child wouldn't. The emotional trauma can be just as bad or even worse. The majority of women who have abortions feel guilt. That's supposed to be 93%. Depression, 88%. Anger, 81%. Sorrow, 92%. Grief, 85%. Bitterness, 75%. Despair, 74%. Shame, 91%. Women who have abortion also report flashbacks of the abortion, 63%. Hysteria outbreaks, 51%. Uncontrollable weeping, 70%. Suicidal feelings, 56%. And general sense of emptiness, 83%. Quick tempers, 59%. And becoming more violent when angered, 48%.
Thank you. I appreciate that. If you have pamphlets that you'd like distributed, feel free to give them to Ms. McKelly. Did you have a question, Representative Holcomb? Feel free.
What is the source of the methodology used for that?
Right here at the committee.
Okay.
Table this and look at that.
All right.
Thanks.
Thank you. All right, thank you, everyone. Did you have,
If I could.
you get 30 seconds, that's it.
I will do it in 30 seconds. Thank you, Madam
I'll cut
Chair.
it off. I will.
Planned Parenthood was brought up. I wanted to say one thing. I'm Brooks Emanuel, Public Policy Director for Planned Parenthood Southeast Advocates. One concern that hasn't been raised yet is the effect on judges. If someone comes before a judge, say, and says she is the victim of incest or rape, currently, if the judge believes her by preponderance of the evidence, the real concern is how is she then, as Representative Wilkerson raised, how can she prove that by clear and convincing evidence? And a real concern here is having a situation where a judge has a minor come in, believes that she is being assaulted, believes her, does not want to send her back, but doesn't feel like she has clear and convincing evidence, and so has to send her back to that home. I don't think we want to put judges in that situation.
All right, thank you. I appreciate it. You should have signed up. You would have gotten 3 minutes. No, you actually went about 50. I was being generous. Anyway, ladies and gentlemen, we understand that this is a very sensitive issue. Many people are very impassioned about this issue, so we will take this under advisement on Senator Payne and Senator McCoon's bills, both of this. But until then, until the next committee meeting, we are adjourned. Thank you.